All right. Hello, Arizona, and congratulations on making it to the top 12. That's a tremendous accomplishment. You should be very proud. My name is Ben Glickman. I'm an attorney with the California Attorney General's Office. I'm also an alumnus of this program. I was on a nationals team way back in 1995. So congratulations again on being here.
How you doing? I'm Hank Chambers. I'm a law professor at the University of Richmond. It's been doing this for about 20, 25 years. It's good to see you all and look forward to a good conversation this afternoon.
And my name's David Hudson. I'm a law professor at Belmont University College of Law in Nashville, Tennessee.
You'd go ahead and introduce yourselves and your teacher, please.
Good afternoon, judges. My name is Shrika Kantala.
Hi, I'm Manvi Harde.
I'm Michael Chen. Our coach is Brianna Willits, and thank you, judges, for all being here this afternoon.
Great, thank you. Manvi, can you talk again? You had an echo. I want to make sure it's...
Oh, hello?
Okay, it's better now. Maybe it was just on my end. Wonderful. Well, if you're ready, we'll go ahead and ask the question and we'll get going. Your question this afternoon is number 1. A result of the decision in Wisconsin v. Yoder is that any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? Whenever you're ready.
Implied rights are rights inferred from other provisions, but are not themselves enumerated in the Constitution. The Ninth Amendment protects people's implied rights from federal encroachment. One of these rights is education, which grants freedom while furthering the common good, as individuals can make informed decisions about representation and government.
I agree with the ruling in Wisconsin v. Yoder because it recognizes the right to raise one's family, an implied personal right. Furthermore, while states regulate education due to their role in federalism under the 10th Amendment, they cannot interfere with the freedom of religion, as the First Amendment has been incorporated to the states under the 14th Amendment's incorporation doctrine, giving it precedence over education.
I disagree, as the 3-pronged Lemon test establishes the Wisconsin compulsory school attendance law as constitutional. The statute did not violate the Establishment Clause, as its original legislative purpose was secular in establishing public education under the Northwest Ordinance. It neither promotes nor inhibits religion, as it only addresses attendance, and therefore does not promote excessive government entanglement with religion. Thus, the Wisconsin requirement for education up to age 16 was constitutional.
The right to education is not a fundamental right in the Constitution, a position the Supreme Court has held in cases such as San Antonio Independent School District v. Rodriguez. However, since states regulate education, many states mention education in their constitutions, or as Wisconsin, in their legislation.
Article 9, Section 1 of the California Constitution states that a general diffusion of knowledge and intelligence is essential to the people's individual liberties. California named education a fundamental right in their Supreme Court case, Sereno v. Priest, after which many states followed suit, with 12 state Supreme Courts doing so in the 1990s alone.
Conversely, Article 11, Section 6 of the Arizona Constitution states that Arizona shall provide school-age pupils a free school for at least half of every year. However, in the 1997 case Hull v. Albrecht, the Arizona Supreme Court, like the federal Supreme Court, held that the Arizona Constitution applies only to the state's obligation to fund a public school system, but does not establish the right to education.
Originally, the Supreme Court held that an individual's religious rights took precedence over other legal rights. In 1958, the Supreme Court ruled in Sherbert v. Verner that the Free Exercise Clause prohibits the government from setting unemployment benefit requirements conflicting with key religious principles, establishing the Sherbert test that laws must be narrowly tailored and demonstrate a compelling interest of the government.
However, the court reversed its position in the 1990 case Oregon Department of HR v. Smith, ruling that religious beliefs do not allow individuals to violate otherwise valid laws, as it creates a slippery slope for other legislation like taxes. The Supreme Court is currently revisiting this position in Fulton v. City of Philadelphia after the city banned Catholic social services from placing children for adoption over their opposition to same-sex marriages.
Additionally, courts emphasize some religions more than others. The framers recognized that religion shall not permit unhallowed perversion by a civil magistrate as it infringes on individual equality. However, the Supreme Court upheld in Dunn v. Ray in 2019 that a Muslim death row inmate could be executed with the Christian chaplain instead of the requested imam under Alabama execution protocol, demonstrating the prioritization of only certain religious beliefs.
The privilege to education, while not explicitly in the Constitution, is enjoyed by the people of the U.S., often through their states. However, education often conflicts with other rights, such as the freedom of religion, a dynamic that the people and courts have carefully balanced throughout American history.
Thank you. I wanted to pick up talking about the challenge of balancing religious rights with other state interests, and in particular, during the COVID pandemic, states have enacted various laws that restricted worship services in order to protect public health. Are those laws constitutional, and do you think the Supreme Court has handled those cases correctly?
In the case of the Roman Catholic Diocese of Brooklyn v. Cuomo, which was what you were referring to, the court essentially signaled that if unconstrained religious observance and public safety are at odds, religious freedom should win. And this is also indicated by a change of the Supreme Court justices lately with the new addition of Supreme Court Justice Amy Barrett. Therefore, the Supreme Court is using their own changes and modern interpretation with the new justices to establish that religious freedom should take precedence.
And I guess, do you agree with that decision making, and how do you square it with Smith? If a state passes a law that says, no gatherings over 25 people, and that limits church attendance, does that law violate free exercise?
No, this does not violate the free exercise clause because it does not restrict religious institutions any farther than any more than other institutions, secular organizations, and we see this in Tandon v. Newsom, a similar related case. And the focus of many of these laws is the common good, an essential facet of classical republicanism. And the federal government and state governments through much of the pandemic has been trying to protect the American people as a whole instead of, say, the specific requirements of a few people that in religious gatherings.
So in a circumstance where the common good would be helped by restricting religion, what should we do in those circumstances?
In protecting the common good through restricting religious freedom, we can see in the court cases such as Cantwell v. Connecticut, how door-to-door religious preachings needed a state license in order for them to be able to proceed, and that's just basically making sure that the religious preachers are not infringing on the privacy of other individuals in their own houses, and therefore they needed a license in order to preach their religious freedom or exercise the First Amendment right of themselves.
However, it's important to note that after everything, the freedom of religion and the free exercise clause is part of the First Amendment. It's one of the most important rights that the American people have. So the freedom of religion cannot be restricted any further than any other right that the people have. So as we mentioned earlier, yes, the common good is at stake, but we must also ensure that our religious gatherings are not not restricted any more than, say, a barber shop or secular gatherings are.
Furthermore, in Federalist 42, Madison himself states that if America is to be this strong, independent nation with a multitude of different economic and socioeconomic statuses, the people must be willing to accept the creation of a strong general government with considerable powers. Therefore, they should be willing to at some times be restricted in terms of their religious freedom if it's for the common good.
In your opening presentation, you mentioned the Lemon test. And that is a test that the Supreme Court developed in 1971 to evaluate whether something violates the Establishment Clause. Do you think the Lemon test should be the primary vehicle to address Establishment Clause issues? And if not, what should we use?
With recent cases, we have seen the Supreme Court using the notion of a substantial burden, which is essentially saying that there must be somewhat of a direct or indirect coercion by the states that is essentially burdening an individual's right to practice their religion. And we've seen this especially with some Native American populations in America with Ling v. Northwest Indian Cemetery Association. And in this, they essentially have issued the removal of some sacred sites because of a national parks territory. Therefore, due to this, they are essentially eliminating, they're essentially not proving that there is a substantial burden, but they've eliminated it for the religious, for the Native Americans. Therefore, the Supreme Court, while has held this up, they've not also been practicing it with Native American populations.
It's also too important to remember that in the context of the Lemon test, it's also been abridged with the case Agostini v. Felton in 1997, which found that entanglements between the church and the state, or entanglements between the government and religion, are not necessarily positive or negative on, are not necessarily positive or negative, and thus that criterion from the Lemon test was removed, and now we only have a two-pronged test, which I do believe is successful in determining if the Establishment Clause or people's rights to religion are being infringed upon.
I wanted to circle back to Yoder. If Mr. Yoder had disagreed with his parents and he wanted to exercise a right to education and continue in school against his parents' wishes, how would the court resolve that issue, or how should the court resolve that conflict?
This goes back to whether or not parents can actively speak for their kids in school systems or in a federal, because children technically cannot vote. They technically cannot voice their opinion in the United States. And we can see this with an Arizona court case, Arizona Christian School Organization v. Wynn, where parents tried to regulate schools and say that as taxpayers, the money that they are putting into the schools is not accurately being used for their children's benefit. But schools are saying, but the school system was saying that no, we know what we're doing and we are protecting your children's rights in our schools. So parents ideally were cut out of the picture when dealing with whether or not their students were getting a proper education and whether or not their rights were being protected in the school system.
I think my teammate does make a good point, as her case is supported by Espinoza v. Montana Department of Revenue, in which the Supreme Court held that state funding for education or scholarship systems could not discriminate against private or religious schools. I think that ultimately parents do hold the right to determine whether or not their children go to school, because education is inherently a system, an institution that seeks to further the common good. And as we see, young people are not given certain rights, such as the right to vote, because they are simply not knowledgeable enough to know what is best to represent them and further their interests in government or in their own lives.
But if education is a public good, and the child wants to go to school, why would the parents' religious rights be considered superior to the child's right to be educated?
I think, again, this goes back to what Michael said about parents being more knowledgeable in society. But when you're talking about the children's right to education, a parent regulating a child's right in education in the education system or representing their child during the voting process does not necessarily mean that children cannot still have their own rights in the education system. Children are given many rights in the education system, and the education system is supposed to support children in making informed decisions so that one day they can be those parents that make good decisions for the betterment of the common good of American society.
While my teammate does make a good point, there are many situations where the Supreme Court has put one's individual rights over the common good. And we've also seen this with religion and education. And in 1983, the United States Court of Appeals for the Fourth Circuit for North Carolina essentially said that a family cannot take their child out of school to freely direct their education because the compulsory education was much stronger than the own parents' wants. And therefore, the Supreme Court also has this basis for saying when does the education, compulsory education, come before one own family's religious beliefs.
Furthermore, to clarify, I believe that parents act as trustees under the trustee theory of representation for their children, that parents can make better decisions just as representatives or senators in Congress can make better decisions for the people. And there is one difference that for children's personal rights, such as if certain religions imply that children must get arranged marriages young, then the children's rights must come into play because their personal freedoms and livelihoods, rights such as life, liberty, and the pursuit of happiness are at risk.
Thank you.
Great job. Let's recognize the students for outstanding participation and hard work.
All right, nice job. I'll let my colleagues kick off the feedback.
Sure, I'll jump in. I like the way you structured your opening in terms of laying out what you were doing with the three different questions essentially that were being posed. So you laid out some real specific markers. Not surprisingly, we went ahead and asked you about some of those markers. So I think it's a difficult situation. It's a difficult question to ask about the kids' role and the parents' role. One of the reasons why we asked about that was that Yoder talks primarily about the state versus the parent. And it's an interesting notion that it's the state versus the parent in that case, because the child was aligned with the parents. But the whole issue sort of flips around when you toss in the child not being aligned with the parents, right? So in that situation, it would seem as though it would be more likely that the state with the child would win as opposed to the parent. So that was a lot of the discussion that we had. It was a good discussion. Which test to use is an important issue. So talking about the Lemon test and other tests, it's good stuff. Clearly you all have thought about a lot of these issues and the conversation was quite worthwhile. So I appreciate having had it and look forward to seeing you again maybe.
I agree. I thought it was a very worthwhile conversation. I appreciate the fact that you incorporated not just U.S. Constitution, but you also referenced some state constitutional law principles. I also appreciate your knowledge of contemporary U.S. Supreme Court cases, the Fulton v. City of Philadelphia, some of the COVID-19 cases that the U.S. Supreme Court has decided recently at a dizzying pace to at least outsiders. And I appreciated your knowledge about the modifications of the Lemon test, as Judge Chambers said. That was excellent. I thought that you really showed some depth in your understanding and really appreciate all the hard work you've put into this. Thank you.
Yes, I would echo what my colleagues have said. I appreciated in the prepared remarks, I thought the portion where you were talking about state protection of education and you contrasted the California Constitution and a California court case with what was happening in Arizona. I thought that was effective to kind of show the differences among the states and how they're approaching this issue. So that was good. On my question about the COVID cases, I was pleased that you knew Tandon and some of the more recent cases. I would have maybe liked to hear how those tie back to Smith and Tandon in particular, because in Tandon it was a neutral law. It was no gatherings of more than 3 households, period. It wasn't specific to religion, and yet the court still found in that case that it was likely to run afoul of the free exercise clause. And so I think that's a kind of a new frontier, perhaps in First Amendment law coming up as the court continues to grapple with those issues. I also appreciated the discussion of is the Lemon test the right test, and you talking about how the courts have applied it more recently, including the substantial burden analysis that they've used, and then Agostini again. I thought that was a good and relevant citation. So overall, very nice job and congratulations.
Thank you, judges.
All right, good luck.
Congratulations again. Great job.